came down for 5. We can find some agreement. We were hoping at some stage that there would have been some case management. That fell through because the purpose for the management no longer existed. So that would have been the ideal opportunity. But no, we have not engaged with each other. And I think it's a wise indication that we should try and meet each other.
Yes. Mr. Mjapelo, do you have any dissenting views on that?
No, I will not have a dissenting view. My initial view was I will not oppose any chance to engage my colleague.
All
my
right.
initial view was that the issue should be decided at once, but I would welcome the 5 minutes so that we can talk and see how we get out of that.
Good, thank you. Then on that understanding, I'll stand the matter down 5 minutes to 10 minutes. So anytime between 5, I'll come back after 5 minutes. But if you need more, the max is 10. Thank you.
Thank you.
The matter stands down then for 5 to 10 minutes.
Thank you, Malone.
Thank you.
Mr. Mojapelo, are you still online?
Yes, I'm still online.
Wonderful. Were you disrobing in that 1 minute that we got?
But I'm wondering if this line is off the record. It definitely is not off the record.
Yeah, the recording is stopped.
Not
Thank you.
Yes, good morning again. What is the position, Mr. Mjapelo?
Yes, Judge, thank you for the indulgence. We have agreed that we will not oppose the application for leave to file the supplementary affidavit, and the respondents will also not oppose our application for condonation.
Oh, okay, that makes things easier. But confirmation, Ms. Killian?
Thank you, my lord. On behalf of the first respondent, we are in agreement as stated by my learned friend.
Thank you. Then on that note, Mr. Mjapelo, you may proceed.
Yes, thank you, my lord. My lord, even though this is not a court and we accept the guidance today, can we still be indulged by referring to you as my lord and judge interchangeably without getting into trouble, as we are used to?
Yes, I don't have a problem with
Yes.
that.
Yes,
Absolutely, yeah.
Thank you. As it would have been evident from the papers, we are dealing with a bid for aeromedical services, for emergency medical services.
So let me just interrupt Mr. Mjapelo and say this. You can assume that I have gone through the papers, so I do not expect you to be as detailed as you would normally do, but certainly touch on what you think is important or needs emphasis on what you have already slotted into your papers, your heads in particular. Ms. Killian, the same applies to you. So, but I'm not going to stop you. And yeah, but all I'm saying, just bear that in mind. It's worth it because it might curtail how long we take on these proceedings, with these proceedings.
Thank you for the indication.
Yes,
thanks.
Thank you for your guidance. We have dealt. Okay, this is what we intended to go through. Just indeed, this is a review of the award of that tender. We intended to deal with the mandate of the SIU, the jurisdiction, but we have dealt with them extensively in our heads, and we refer to the guide. In that regard, we refer to the letter judgment. And perhaps I will deal with the factual background, briefly deal with the factual background, and thereafter.
Let me just ask just on the jurisdiction of the SIU, is it challenged? If I remember, it's not challenged, is it?
No, it is not challenged.
So maybe you can skip that
Yes.
because it's not challenged anyway, so it stands.
Yes.
Yes, all right. Factual background, yes. Sorry about that.
Yes, thank you. Then after dealing with the factual background, we will deal with the grounds of review, focusing on the law. And with your guidance, we hope to be done within an hour or less.
Yes.
Yes.
Thank you very much.
Yes.
You may proceed.
The advert for this tender was done during March 2015, and the advert to this tender was done after the department, the third respondent, which is not opposing today, has requested the National Treasury to be relieved from the tender that was administered by the National Treasury on behalf of the provinces. So they decided to do this on their own. The advert came out and it stated that this tender was for 12 months. The advert is attached as an extra JN20. It specifically mentioned that the period is 12 months. The 12 month is significant to our grounds for review. Thereafter, after the advert, still in March 2015, there was this compulsory tender meeting where 9 companies attended. Out of all those, I mean, during that attendance of those companies, there was again a clarification because there might have been a discrepancy, but the clarification was, and is recorded in the minutes, that this tender is indeed for a period of 12 months. So after that clarification, only 4 companies bought the tender documents. The closing date of the tender was the 17th of April 2015. And in the record here, we've done our investigation, we've requested documents. We do not have any documents that shows which company submitted the tenders. This is also important. The first time that we hear about which company submitted the tender will be on Annexure JN31, which is the Technical Evaluation Committee. The Technical Evaluation Committee, Annexure JN31, the first paragraph reads as follows. The purpose, to report back on the findings of the technical evaluation of bidders for aeromedical services, 2 companies submitted their bids, and those companies are named as 1, Vusa Medical and Halo Aviation. The Technical Evaluation Committee recommended Halo, and they called them Halo. So from their recommendation and from their recording, we know it's only 2 companies. Then the next step is the Bid Evaluation Committee, the BEC, that's set on March 2015. What is significant with the BEC is that we now see the name BUTHELEZI. The BEC now states in their minutes, which is an extra JN33, they say offers were received from the following bidders. And then they name the first respondent as Halo Aviation and BUTHELEZI, HEMS, trading as BUTHELEZI EMS. And those are the successful bidders. They are now called the joint, operating as a joint venture. And this is the first time that BUTHELEZI is being named. And I'm remind my Lord that we don't have any register or any documentation that shows how many companies did tender. We see BUTHELEZI for the first time at the second stage. The recommendation of the BEC, the Bid Evaluation Committee, recommended 3 years instead of the advertised 12 months.
And still there? Oh, okay.
Yes, and then the method. I beg your pardon, my Lord. The method.
No. So, by the way, let me just put it on record. I can't see. So when there is a pause, sometimes I think that I'm off the screen or there's a glitch. So that's why I wanted to find out whether you're still there.
Yes.
Just bear that in mind. So yeah, your voice is very important. You can't talk or you can't indicate by just chatting to me. That's okay. Continue.
Yeah. Fortunately, it looks like the reception today is perfect. Yes,
it's perfect.
Step, the next step was the BAC, the Bid Adjudication Committee. I just concluded by saying the BEC recommended 3 years instead of the advertised 12 months. Then we are now in June 2015. The BAC, the Bid Adjudication Committee, receives the recommendation of the BEC and they don't support it. They don't support it, and they issue one of their instruction was that the Secretariat be requested to obtain information about the amendment of the contract period after the closing of the bid. They said again, that is the BAC, now we are in July, a month later. When they sit in July, they now make their decision. They recommend the tender again to the JV, but they say the tender should be for a period of 12 months. And these 12 months, they say in the very same sentence where they recommend, they say the department to consider a bid for a longer period. This is what the BAC has said. I'm quiet because I'm looking for the exact sentence. So in our submission will be that they looked at the advert, they looked at the clarification that the bid is for 12 months, and they advised the department, that is what they said, that if the department wants a longer period, they should consider a bid, meaning they must re-advertise, or they must advertise after the end of the 12 months. That was in July, 6 July 2015. Recommendation of the adjudication committee now goes to the accounting officer, still in July. And JN44, the accounting officer does not agree with the BAC because he now refers the matter back to the BAC and the BEC with an instruction that both of them must determine the duration of the contract. Very strange in our submission because the duration is advertised, the duration was clarified. Mm-hmm. Then we are in July. The annexure there is JN44. 2 or 3 months passed, then we are in September. In September, there is a recording, and that recording is at page 00301 of the papers. This is the recording that shows that the BAC and the BEC have met. It is annexure JN45. I know Malot has read the papers, but I beg leave to read these paragraphs.
Yeah.
It is a recommendation dated 23 September, internal memo to the accounting officer. This must be a report of what the accounting officer has instructed the BEC and the BAC to do. Paragraph 2 says, the recommendation to award the bid to Halo Aviation and BUTHELEZI HEMS, trading as BUTHELEZI EMS CC, initially for a period of 12 months, was handled by the Departmental Bid Adjudication Committee on 06 July 2015. On approval of the bid, the accounting officer indicated that the bid be referred back to the Departmental Bid Adjudication and Bid Evaluation Committees to determine and agree on the best position for the department in terms of the period of contract where these committees had differences in their recommendations. That is paragraph 2. My Lord will remember that the BEC recommended 3 years, whereas the BAC recommended 12 months. Paragraph 3 reads as follows. A joint meeting was held on 23 September 2015, and the discussions were as below. Bullet point 1. The bid was advertised to ensure that the evaluation is done in a fair, transparent, equitable, and competitive manner. The evaluation of the bid was done considering both proposals of 12 months and 36 months durations. Bullet point 2, the committees considered the cost effectiveness of both proposals. In terms of these options, the option of 12 months offers a higher monthly fee of 2.2 million than this 36 months, 1.5 million per month after 3 months. Additionally, 36 months provides an added advantage to the department of reaping the benefits from training of officials in the aeromedical services where value for money can be realized. And then paragraph 5, then they recommend, going to read paragraph 5.2. It is recommended that based on the analysis above, the committee determine that it will not be cost effective to conclude a contract for this service for 12 months period. The department will benefit if the contract is concluded for a period of 3 years. Therefore, it is recommended that the contract be concluded for a period of 3 years. That was on 23 September 2015. And the accounting officer agreed with them because immediately on the same day, 23 September, a letter of award, JN46, was sent to the JV. And then they accepted the following month. That is the brief background of what happened. Then we'll briefly deal with the issue of, in general, that this tender award is unlawful. And my Lord will know that we're relying on the Constitution, Section 217. I don't have to repeat what it says, but I think it is important that I state what the Constitutional Court has said is the purpose of Section 217. It has been repeated also by the SCA. The Constitutional Court matter will be the matter of TASIMA, Department of Transport versus TASIMA. It's in our heads. And the SCA will be the Vela IT versus the Premier of Northwest Province. 3 purposes of Section 217. 1 is to prevent patronage and corruption. 2 is to promote fairness and impartiality in the award of the public procurement contracts. And 3, enable the state to secure services at the best price in the market. And it's worth repeating, but it's part of our law that any interpretation of the documents should be made in relation to the purpose of the law. And that is the purpose that the Constitutional Court and the SCA has given to the constitutional provision of Section 217. And still dealing with our submissions on the legality, it is a well-known principle, also comes from the Constitutional Court, the Pharmaceutical Manufacturers Association. And I will just summarize that it is a well established that the legislature and the executive in all spheres are constrained by the principle that they may exercise no power and perform no function beyond those confronted, those conferred upon them by the law. I beg your pardon, my Lord. There is an issue, although it's not loudly argued, but that the complaints that we are raising here in respect of the legality of these tenders might be so trivial and inconsequential that they don't need the attention of the tribunal. That may be so, but we refer the court, the tribunal, to the all-pay case. I'll just refer to the paragraphs that I've quoted here. The Constitutional Court in the all-pay case, it's also part of our heads. It says in paragraph 22, that is all-pay 2. This judgment holds that A, the suggestion that inconsequential irregularities are of no moment conflates the test for irregularities and their import. Hence, the assessment of the fairness and lawfulness of the procurement process must be independent of the outcome of the tender process. So there is no issue. If one might feel that the complaints that we are bringing before the tribunal are inconsequential irregularities. The Constitutional Court continues on paragraph 24 to say, we conclude that paragraph, if the process leading to the bid success was compromised, it cannot be known with certainty what course the process might have taken had the procedural requirements been met. And the triple PFA, the Preferential Procurement Framework Act, has a definition of an acceptable tender, which has been referred to in the Sapela judgment. The Sapela, the Chairperson Standing Committee versus Sapela, it's an SCA judgment. It's referred to by both parties. An acceptable tender, as defined in Section 1 of the triple PFA, mean any tender which in all respects comply with the specifications and the conditions of the tender as set out in the tender documents. And they repeat the doctrine of legality, and they repeat that it demands that the legislature and the executive in all spheres are constrained to exercise power and perform their functions in a manner consistent with the law. The acceptance by an organ of state of a tender which is not acceptable within the meaning of triple PFA would amount to an invalid act that would ultimately fall to be set aside. So acceptability, the SCA say, is therefore a statutory threshold requirement. Having briefly dealt with the law in general, I would like now to go to the specific complaints. And the first complaint that we'll start with is the amendment of the tender period from 12 months to 3 years. My Lord will remember that I stated during the brief background that the advert specifically mentioned that it is for 12 months. What the public knew out there was that this tender, if you are interested, the duration is 12 months, and this will have influenced some of the potential bidders. No wonder, and the investments that are involved, maybe 12 months would not have been viable for other tenderers. So they did not even participate. That was on the 13th of March. 10 days later, 23 of March 2015, there was a compulsory bidding. Now we have 9 companies out of the whole republic. It was reaffirmed on that day. It was reaffirmed that the bid submitted their bid. We don't have those records. The BEC on the 10th of June recommends, and we're dealing with the period here, that the tender be awarded to the JV and that the contract be concluded for a period of 3 years. This is clearly contrary to the advert and contrary to the briefing session. The BAC, as I've stated, rejected that and issued an instruction that the Secretariat was requested to obtain information about the amendment of the contract period after the closing date of the bid. And the BAC, as I've stated, the following month in July, made a decision that the contract be awarded to the JV for 12 months. And doing that, they stated that the department must consider a bid for a longer period. I've already made submissions on that. The HOD referred the matter to BAC and BEC to determine the contract periods. And they came back on the 23rd of September and resolved that the bid is for 3 years. And that's how the bid was awarded to the JV for 3 years. This it's worth mentioning again that is contrary to what the public knows in terms of the advert, and is also contrary to what the other 5 of the 9 bidders that were there during the compulsory briefing session. We refer, my lord, to the case of Muiponi The full citation is paragraph 50 of our heads of argument. That is the City of Tshwane Municipality versus Moiponi Group of Companies, the 2024 judgment, also dealing with the amendment.
So, Mr. Mshapel, would it have made a difference if only VUSA and helicopter aviation, whatever, are the only companies that submitted a bid, assuming that the other 7 did not?
Okay, I beg your pardon, my lord.
But let's assume that the 9 companies turned out at the briefing session, and we don't know how many of those actually submitted, but we know that Halo and VUSA ultimately submitted. The question is, does it matter that we do not know that they submitted? Or had they, would it make it, is there different, would it have been, would there have been a difference had they submitted and now that they have not submitted?
Yes, let me just see if I understand my lord's question.
Yeah.
Currently, I'm dealing with the issue of 12 months versus 3 months.
Yes, what I'm leading to, the arbitrary change of the period.
Yes.
Would it have been of, now that we don't have papers from the other 7, the change from 12 to 3 or 30 months, from 12 months to 36 months, are they really affected or not?
Yes.
Those that did not submit.
Yes. Thank you for the clarity, my lord. I do understand the question now. That is the substratum of our complaint and our argument here. The principle of fairness dictates that everyone, before we even talk about the 9 companies that attended the compulsory briefing, everyone, all the public should have the same information. And that information that is out there in the public affects their decision whether they are going to submit their bid or not. It is unfair if that information is changed at a later stage. And in our heads, we refer you, my lord, to 3 cases. That is the Moiponi, that is the first one. And then the second one is the Tuabe, the third one is the fire camp case. In Moiponi, the court concluded that as a result of the defendant being given an opportunity to satisfy the tender requirement after the closing date of the tenders, violated the requirement to act in a manner which is transparent, which is fair, which is equitable, cost-effective, competitive, because tenders must comply with the tender requirement as at the closing date, and other bidders, and this is my lord's question, other bidders were further not given the same opportunity. So this might be different in that they were allowed to correct, but the substratum of this is that changes are not supposed to be made after the closing date. And then in Tuabe, the court stated that, and it's there in our heads of argument, I agree with the defendant that the amendment of the bid condition subsequent to the closing for the bids offends the provisions of section 217. The initial bid conditions in respect of pricing offered a fair, equitable, transparent opportunity to the public to submit a bid. The moment the defendant changed this condition and made the amended conditions known to a select few, the bid process became unfair, inequitable, and without transparency. The requirements of section 217 that the bid process must be competitive was also violated. Only a select few could, after the close of the bid, submit competitive bids. The court went further to state that the plaintiff's submission failed to take into account that the public, and more specifically, potential bidders, were unaware of the amended bid condition. In order for the bid process to be transparent, fair, and equitable, the amended condition should have been published to all interested parties, an opportunity to submit a competitive bid. And the last case that we refer to is the Firecam case. It's also there in our heads, Premier Free State versus Firecam. And in paragraph 30, on the concluding part of the paragraph 30, the court says, yet another requirement is that competitors should be treated equally, in the sense that they should all be entitled to the tender for the same thing. Competitiveness is not served only by only one or some of the tenders knowing what is the true subject of the tender. So all these cases, and just the principle of fairness, with or without the Constitution, says that the people, the potential bidders must compete for the same thing, and the information that they have influence them whether or not they're going to bid. So we submit that just on this point alone, this tender, this award should be set aside, as it was definitely untransparent, unfair, and unequitable. That was the first ground for complaint. The second ground for complaint is a little bit easier. Is in general, we submit that the committee members were not appointed in writing, contrary to what the SCM policy states and contrary to what the National Treasury Guidelines states. I'll just read one of the clause in the SCM policy, and I'll not read the others, but they more or less say the same thing. Clause 3.4.1 provides that the accounting officer shall appoint the bid adjudication committee in writing and will also determine the term of the office. What my lord will have realized in our founding affidavit is that we did request the letters of appointing the members of the bid evaluation committee and the bid adjudication committee, and we did not get those letters. The conclusion, and there is no answering affidavit from the department, and all the first respondent can say is that they are not part of the internal process. The conclusion that we state on our evidence, which is not contradiction, is that the appointment were done contrary to the law because they were not done in writing. And that goes into the lawfulness of the activities of the BEC and the BAC. Now, the third complaint or ground that I want to go into is what we call the CIBD. The CIBD, the Act stands for the Construction Industry Development Board Act 38 of 2000. This tender had always had a construction element to it. When in January 2015, the internal memos were drafted, and we show that in paragraph 59 of our heads, it was stated that we also, this is a quotation from that memo, we also request approval to construct a hangar for the helicopter at Pelonomi Hospital so that the service can be stationed and respond from our facility. So even before the advert, it was always known that there's a construction element. And during the briefing, the compulsory briefing, 4 points were recorded, which also highlight the fact that this tender has a construction element. And we summarize them in paragraph 61 of the heads. The bidders must submit a detailed plan and pricing for the construction of the helipads certified by CAA. The helicopter hangar must be erected and built by the builder and should have a backup power source during the load shedding. All equipment and construction work to be done by the bidder will be handed over to the department as property of the state. Last one that was recorded there, the project for the construction of the helipad must not exceed a period of 6 months. So it was always clear that there is a construction element. When there is a construction element, that CIBD...
Just help me here for just interest. What is the difference between this helipad and a helicopter hangar or and a hangar?
My understanding will be a hangar is like a garage where the helicopter parks. The pad will be the parking where it lands. So they will. That's just my understanding. And
yeah, I've been trying. Yeah, all right. Thanks.
Yes, yes. But the hangar is the garage. It's inside where they park.
But yes, no, the helipad is not normally on top of a building or something, as is the case here.
The pad, yes, depending on the area. Sometimes it's on the ground. They put a tar road and they put a circle and they put a H for it to land. Sometimes it's on top of the building. Yes.
Okay. Thank you.
Yeah. Yes. That's not a scientific answer, but that's my knowledge. Yes.
Yes.
So when there is a construction in a public sector, it is important the act regulates that